Thank you, thank you, thank you. Ladies and gentlemen, we take the pleasure to welcome you to Lego Tech Dialogues. It's a beautiful day. My name is Tony Kire Galandi. I'm the host for this podcast. An advocate. I manage a law firm called Diamond Advocates. I'm very passionate about tech. And I'm glad to have you here on this long-awaited day. As all of us are aware, the world is taking a trend in digital transformation. And there is no better time than this one to have you join us as members, nominees to the Judicial Service Commission. As advocates, we feel that your opinion, your aspirations with respect to digital transformation are very key because, as you may know, the digital space is extending to the legal practice we have today. As you know, most of the challenges we are facing in judiciary with respect to backlog could be solved by the digital innovations. So you are the best people to have on today's discussion, on today's topic. We feel very humbled and honored to have you. I will start by introducing my co-moderator, Ruth Mohawe. Ruth Mohawe is a technology associate with S&L. She holds a master's degree from the celebrated Harvard Law School in AI, governance, technology, and the law. She is an advocate of the High Court of Uganda and has advised a number of institutions on technology and AI. Let me take the pleasure to welcome Ruth Mohawe to take her seat. Let me also have the honor to introduce one of our panelists, Counsel Paul Muchibi. I'll give you a small brief about Paul Muchibi. Paul Muchibi is a distinguished legal professional, currently serving as the head of the Department of Law, Reporting, Research and Reform at the Prestigious Law Development Center in Kampala, and is a founding partner at Muchibi and Cheyune Advocates. His leadership extends to chairing Research and Publication Committee of the East African Law Society and Secretary of Uganda Law Reports, the only official law report in the country. Put your hands together for Paul Muchibi. Kindly come and take up your seat. Let me also take the honor to introduce to you Advocate Mariam N. Mbabali. She's an accomplished advocate, arbitrator, mental health practitioner, and entrepreneur. As the managing partner at Kabuzire Mbabali Company Advocates, she combines her expertise in corporate governance, strategic leadership, and law firm management to deliver cut-edge legal services. Mariam is also a thriving entrepreneur owning a couple of thriving businesses. She's an advocate for gender equality and senior member of FIDA Uganda. Her work reflects a commitment to empowering women while promoting inclusivity. She's a company secretary to various and sits on various boards. Put your hands together for the celebrated Mariam N. Mbabali. Let me also take the honor to introduce to you Olisangawa Omusajja Asinganze. Ellison Karuhanga holds an LLB and a diploma in legal practice, and an LLM specializing in oil and gas. He is a member of Uganda Law Society and East African Law Society with extensive experience in corporate law, oil and gas, litigation, and criminal law. Ellison is a seasoned litigator with significant experience both in the civil and criminal bar. He has represented clients in the Supreme Court, Court of Appeal, East African Court of Justice, and international arbitration forums. He's also served as a state attorney in the Justice Ministry. Put your hands together for Olisangawa Omusajja Asinganze. Let me also take the honor to introduce to you our fourth panelist, who is going to be online because of traffic, Professor Christopher Mbazira. Mbazira is a professor of law at the School of Law of Makerere University. He's also a coordinator of Public Interest Law Clinic and a founding member of the Network of Public Interest Lawyers. In 2021, Mbazira won the Uganda Law Society Award for his distinguished service in legal education in Uganda. He's an active member of the Uganda Law Society and has also served on various committees. He is also a seasoned practitioner in public interest litigation and human rights activist. One of his recent achievements is the revitalization of amicus curiae practice. He brings a wealth of experience as a hybrid lawyer. Put your hands together for Professor Christopher Mbazira. Ladies and gentlemen, our next panelist is Dr. Patricia Atim. Dr. Patricia is an academician with a PhD, an LLM, and a diploma in legal practice. She's a human rights activist and an advocate of the High Court of Uganda. Currently, she's a lecturer and head of legal aid unit at the Public Interest Law Clinic, School of Law, Makerere University. Her professional and research interests is human rights law, governance, family law, children's rights, gender and the law, disability and administrative law, and clinical legal education. Put your hands together for Dr. Atim. Our sixth panelist is Alex Rezida. Alex Rezida is an advocate of the High Court of Uganda, a commission of oath, and a founding partner of the renowned Nangwala Rezida and Company Advocates. He has been the legal practice with particular emphasis in areas of land law, media law, commercial law, company law, and related litigation. He has served as the director of boards of some organizations, including but not limited to Reach Out, Mbuya Community Health Initiative, Hans Newman Steng, Harris International Limited, Reham, Sea World Energy Services Uganda Limited. He's also a council member of St. Ignatius University, Kabale. Put your hands together for Rezida. Ladies and gentlemen, this is not a debate. It is a panel discussion. We want to hear from our colleagues who are going to represent us in the Judicial Service Commission so that they speak to us, because one of the challenges and the aspirations of the society as members is digital transformation. And there are no better candidates apart from these who are going to sit on the panel that is going to interview our members of the bench. So their passion for technology really is a welcome gesture. And I'm really very grateful. And I say thank you very, very much. Ladies and gentlemen, I also want to take this opportunity to thank the Council of Uganda Law Society for promoting digital transformation. I also want to particularly thank the President Uganda Law Society, President Isaac Chimeze Semakade, for his relentless push for the digital adoption. It's not an easy push because naturally we all do not love change. We want to stay in the same status quo. Ladies and gentlemen, in the interest of time, I'll just give a few guidelines. In the interest of time, we are going to have questions that are going to serve across board. And we expect that the panelists should be able to give us their opinion, their observations in 3 minutes for every question. And we will signal, but also we know for a fact, these are sticklers of time. Ladies and gentlemen, I hope I've not wasted a lot of time. I will hand over the call to Ruth. Thank you.
Thank you so much, Tony. And good evening, everyone. Good evening, our panelists, senior members of the bar. Good evening to our audience in the room and those that are joining us online. We're happy to have you here. Thank you for giving of your time. Specifically to the panelists, thank you for offering of yourselves, one, to serve. I know you've been running a spirited campaign over the last couple of months, so thank you for keeping it going. But more importantly, thank you for coming to be a part of this conversation. As my co-moderator has mentioned, digital transformation is at the heart of the economy, at the heart of the rule and the practice of law, and at the heart of the mandate of the Uganda Law Society. And so it's no surprise that your electorate expects you or demands that, you are able to share your thoughts and speak to how exactly you are looking at leveraging technology to serve the objectives of your positions, of the Law Society, and the Judicial Service Commission. So I will be posing the questions. Feel free to share your thoughts. You may speak to, if a particular question or scenario speaks to something within your mandate or within your, what your campaign is hinged on, feel free to reference that as well. So I think the questions that I ask will start from my right and go that way, and then from Tony we'll start from the other way. Okay, so we're diving straight into it. Yes. So I think we may have seen that today we are going to talk a bit about case backlog, but also to try and go beyond or behind case backlog to try and understand what exactly that entails, what exactly is, what are the key pain points, and how technology is being used or can be used to solve case backlog and other issues. So the first thing I want to ask, because it has been mentioned so many times, we're going to reduce case backlog. Sometimes technology is referenced as being a tool, either that has already started making progress in that area or that can be leveraged even more to reduce case backlog. So we just want to get a sense of your views, your individual views based on your practice, what you're seeing here. How successful do you think technology has been in reducing case backlog? And if you can, you can say it's been very successful, but if you have a different view, where do you think the gaps are? And allow me to start from my directorate.
Thank you, Ruth, and good evening, everyone here and those online. Paul Muchivi is my name. I'll go straight forward to the question. Briefly, I'll highlight the technology journey in the judiciary and the bar. Our technology journey started from CAS. CAS, that is the Court Case Administration System. We had CAS about more than 2 decades ago. What was CAS doing? CAS was simply helping track movement of a file and status of a file. You could just have on the interface what stage is that file. Is it fixed for hearing? Is it coming for scheduling? You could get that status. But the question is, where would you get that information? You again move to court. You say clerk or the system administrator to check for you. So still it was not very effective because it's still involving movement, and the users like the advocates cannot use it. Even the judges, most of them could not use them. They were asking clerks and the system administrators. So we moved from there, started moving slowly, and we started sort of video conferencing. And the only facility we had was Major at Uganda Road, Chief Magistrate Court. And that worked so much when we had issues to do with the political cases involving politicians, where they never wanted to bring them to court to try them from wherever they are in prison, but proceedings are being viewed virtually. That was, first of all, a political issue, trying to manage the crowds who were always crowding with these politicians. And secondly, it was only in Kampala, and even a judge had to make booking at Uganda Road to use that facility way in advance. Any judicial officer who wanted had to book that facility, meaning it was still not very effective. Now, the judiciary had already a program, a strategic plan, which was longer, started in 2002, to automate its systems. And that is the product we are getting from around 2019, ECMIS, the Electronic Court Case Management Information System. ECMIS started being tried out, but COVID-19 rejuvenated it, whereby the judiciary now was so much into thinking on alternative ways of dispensing justice, being that we are not in the normal days. One of the events was they even started rolling out delivery of decisions using emails, and there was always delivering rulings using emails. It happened, and also hearing bail applications during COVID. We had one of General Tumukunde, which was heard virtually, and also the ruling delivered virtually because of COVID-19, among others. Now comes 1st March 2022, we went live on ECMIS. ECMIS was switched live. And when ECMIS was switched live, we started having a few items being done digitally, but still amidst opposition and what have you. Now, going to the real question, has technology helped to reduce backlog? Has it helped in administration of justice? I can say it has helped, but the levels are still very low for obvious reasons. One, we have not even integrated the judiciary with the other organizations. For instance, NIRA, you go to family division, they want to verify a death certificate, they write a letter to NIRA, and NIRA has to respond in what? In writing. Yet, judiciary has ECMIS, NIRA is also has already embraced technology. Why would we take all that time going into manual letters to verify a death certificate, to verify a national ID? Talk about Office of the DPP. The DPP in its technological journey developed what we called PROCAMIS. PROCAMIS is Prosecution Management Information System. I've done study on PROCAMIS, but PROCAMIS completely failed from start. It didn't go far. They only stopped at scanning documents, trying to upload them. So Procamis was not also productive. Yet we needed the judiciary to link with DPP, to track cases, to know which prisoners have delayed, also come to prison, but could have a record knowing which prisoners have been in prison for so long, which cases are not being tried, which matters are pending bail. You could easily track it. Then go to prisons. Still, there is no linkage between judiciary and prisons. Today, I've heard that I was reading the judicial report launched 2014, 2024, 2025. They reported of a person who was detained under a ministerial order and has been under detention since 1999. 1999. Even some lawyers were not yet born now. He has been in detention under minister order, but the system could not track. That matter could not be traced. If we had a linkage between prison and the judiciary, you could easily follow such matters. Secondly, we still have a challenge of virtual hearings. Virtual hearings, recently I was in Nairobi, and in Nairobi I got a very different experience. I was also still trying to study about their virtual proceedings. And Nairobi now, advocates no longer go to court. It is about less than a third of the cases that they can go to physical courts. I visited 5 floor chambers. They were in their chambers proceeding, the clients at home or places of work, and the judge is also in his chambers proceeding. No need of going to physical court. Here we are still fighting, we are still uploading, we are still printing, but again we are saying we have gone virtual. So there is still a level of a mix of so many things, and also the challenge of digital literacy is still preventing us from reaching where we are. Most of our judges, you go to court, they have huge files, but they are telling you they are using ECMIS. And you tell a judge, I uploaded this document on the system yesterday, and the judge is asking you, can you give me a copy? Now, when you ask me a copy, you are going manual. Yet, the document is already on the system, but the judge is looking for the secretary to check the system. They have also not embraced the system well. So, whereas there is good intentions, there are some progressive steps to digitize court processes. We still have very many hurdles, and one of the biggest hurdles also is change management between the bar and the bench. Most people have refused to migrate from the manual system, and most advocates have employed the clerks to use ECMIS. They don't use ECMIS. The clerks are the one doing the work. So that is all defeating the system, and that's as what I say, that the levels are still too low. We are not even yet 15% of digital transformation. Yet we have launched this since March 2022. So there's quite a number of challenges, and I must say that we shouldn't be very much proud. But if you look at like Kenya, they have started around 2016. Around 2016, Kenya was around 2018. But the levels there are very high. You can even finish a case without going to court physically. So we need also to apply certain interventions and move to that direction. Thank you.
Wow, thank you so much, Mr. Muchivi. I feel like that's a very rich and comprehensive overview, and also provided context to the conversation. Ms. Mbabali, from your experience managing a law firm, do you agree with those challenges? Do you think there's more? Because what I hear from him is so little done, so much more to do.
Thank you, everyone. Thank you for the organizers, Diamond Advocates. I applaud you. This is a very good initiative. Mariam Babali is my beautiful name, and I'm humbled to be here. Yes, I think we should give credit where it's due. We have moved away from the paper chaos. There's a lot to be done, but we should give credit where it's due. Yes, the movement is still uneven. We are still moving from Kampala to Chiriandongo because some courts haven't yet gotten ECMIS. Yes, but at least there's a few wins, and we should clap for those wins. though we're still looking at documents filed upside down by some advocates. Yes, we are still looking at the quality of data, the quality of the whole case layout. It's still wanting, but at least we are getting there. Every 1,000 starts with a single step, so it's a step in the right direction. And I applaud the ECMEs for the steps they are taking. Yes, they can do more. Another thing that I see in our farm, and I think most of the practicing farm like myself, there's a lot that needed to be done. We needed to get training. We are all not on the same level. We're not going to compare apples with oranges. People needed to be trained. We still have people that do not have access to the connectivity, those of Kampala we are having, but they still have to use ECMEs if their areas have it. So that uneven representation, I think, is wanting, and we ought to recognize that. And we need to look at we need to use technology beyond ECMEs, but also look at the vulnerable groups that access these courts. In law school, we had, I went to school with some of my colleagues that have had hearing problems. They were blind and they were using all these gadgets, and the courts haven't moved from allowing those litigants and fellow lawyers to use that on that level. So when you speak technology, legal tech, it goes beyond the usage of legal tech, but also the court users and representation. Are we looking at all the lawyers, those with disabilities? Are they accessing legal tech? You're blind. Is legal tech catering for that gap? No. So I think it needed to be looked at a wholesome level. That are we looking at all the vulnerable groups? Are we looking at representation? In Uganda, I think we're at a level where at least 70% are having smartphones. Why aren't we getting SMS alerts of the cause list? Why do I have to travel all the way to Gulu to be told the case is adjourned? Couldn't we get SMS alerts? Can't we start on the bare minimum? When we say technology, we shouldn't look at the flamboyant big picture, but let's start with the basics, because that's still technology. You have your phone, you should be receiving some updates, bare minimum, but we are still lacking in that area. Yes, coupled with what Council has spoken about, to me, those are the highlights that I think we can do more. So thank you.
Thank you very much for bringing us, back to the basics, to the grassroots. I really appreciate that connection. I'm going to move forward to Mr. Karuhanga. Just some caution. I have received serious warning from my bosses that I am allowing us to, so kindly remember that we should try and summarize our views in 3 minutes. Mr. Karuhanga, again, leveraging your experience as a senior practitioner, I want to bring you back to technology and case backlog. Would you say you've seen that impact?
Thank you, first of all, for the opportunity to be here and for the insightful topic that you've selected and for that wonderful question. Does technology have an impact? First of all, there's been great technological improvement. We even have virtual hearings. Mm-hmm. We have regulations on virtual hearings. Mm-hmm. We have an electronic case management system. Even the recording system in the court. Back in the day, court used to be by longhand. So technology has certainly eased the work of the court. But in specific answer to your question, has technology helped to do what you say, to reduce case backlog? The answer is absolutely not, unfortunately. In 2015, the judiciary conducted a census and discovered that 25% of cases in the judiciary were there for more than 2 years. At that time, there were about, I don't have the number of head, but about 7,000 or 8,000. The then Chief Justice put in place a backlog reduction committee. In 2017, I think we had a full and proper census in 2017. And there were a number of things which were suggested to help reduce this backlog, which was at about 27%, and I think had then been settled at about 17,000 cases. A few days ago, the Chief Justice launched the annual judiciary report, and guess what? Backlog was at about 27%. Not only that, in real terms, it was about 25%, I think, and they said there had been an improvement by 2%. In real terms, when we were nominated as candidates for the Judicial Service Commission election, backlog was 43,000 cases. Now backlog is 46,000 cases. We've had an increase, 46,000, I think 500. We have an increment of 3,500 new backlog cases. 3,500 new backlog cases. Although they say it has reduced in percentage terms. In fact, if you move it away just from backlog and go to case disposal, according to that same report, the case disposal reduced last year, 58% of cases were resolved. This year, 57% of cases were resolved. So overall case reduction went down. Meanwhile, technology went up, but we also had a 50 billion shilling increment in the judiciary's budget. In fact, since 2021, the judiciary's budget has grown more than 122%. That means that it has doubled and some since 2021. I think it used to be about 190 billion or 200 billion thereabout. It is now about 450 billion. We've put more money, more resources, a deeper use of technology, and we have been able to successfully produce worse outcomes. That is the statistical reality. Because the thinking in 2015, the thinking of the Backlog Reduction Committee of 2017 cannot continue to be the thinking in 2027 as our population grows, as transactions become more complex, as a lot is happening. So we need to use technology and harness technology better. The truth is, while we've had more technology, you can't say that we've had ICMIS, for example, is in only, I think, 11.5% of the courts in this country. So while it is a great achievement, we need to roll it out more. We need to have more ideas. I see that the Judiciary Committee, is proposing regulations on mobile courts. We need to start seeing mobile. We need to start seeing mobile courts. We need to start seeing, frankly speaking, more manpower in the courts. We've been proposing for a long time that we need to activate Article 142(2) of the Constitution to bring advocates into the court system to help clear the backlog, because the state of the business of the court so requires. Backlog is going up year on year. From when we started tracking it at 17,000 to 46,000, 46,000 today. If we continue thinking the way we are thinking now, we are going to wake up and backlog is going to be, it has already become too much. The average remand time, according to that report, is 20 months. Can you imagine what 20 months would do of your life if you are locked up in a jail cell? The fact of the matter is that backlog means accusations have become convictions. Land disputes take 10 years. Even in that very report, we are seeing land disputes taking 10 years to resolve. Land disputes are taking 10 years to resolve. Commercial court is sitting on 77 trillion. In the Tax Appeals Tribunal, they assume that backlog is 9 months. In the judiciary, it's 2 years. But what is the Tax Appeals Tribunal working towards? It's working towards bringing backlog down, they told us in a space we had, to 6 months. So for them, their target is that our definition of backlog must keep coming down. In the judiciary, if you solve your dispute in 6 months, it is prima facie evidence of corruption. So we need to have a new thinking in the way we solve this problem. We need to invoke Article 142.2. We need to have the mobile courts. We need to increase on not just electronic case management, but virtual hearings as much as possible. But in my view, and I've been saying it for a while, backlog is an enemy and it needs to be fought the way enemies are fought. We need to fight it like a war. It is a cancer to our judicial system. It is killing hope. It is burying dreams. It is terrible, and it's a terrible thing that needs a serious solution.
Thank you so much, Mr. Karuhanga. I think it's very concerning to hear that I think technology can go up and the problem gets worse. It actually got me wondering whether maybe it's because we have enabled people to file disputes and faster, and we have not enabled the bench to resolve disputes at the same speed. So I think that's very, very insightful and very concerning. Allow me move to you, Dr. Tim. We would like to hear your views, and I think particularly we know that you're head of the legal aid unit at PILAC, and you have a wealth of experience in that space. We've had views from the rest of the candidates about the discrepancies in technologies reaching areas outside Kampala. We're aware that your experience allows you to have first-hand interaction with some of these courts and these spaces. So we'd also like to hear your view from that perspective as well. Is technology bringing solutions to this problem?
Okay, good evening, listeners in the virtual space and those here. Thank you very much for convening this meeting, this conversation. Let me also take the opportunity to thank the legal fraternity and for really keeping the pace, and R&B for digitalization, championing the digitalization agenda, and we've really seen them in action. I'm Patricia Tim Podong. One of my goals or vision as we campaigned was consolidating the gains that we have so far received as a country in enhancing access to justice for all in the spirit of our 1995 Constitution. My colleagues have very well spoken to the genesis of technology in our court process or judicial process and the benefits so far. I agree with them in many respects that yes, we can indeed celebrate gains with the emergence of technology in the courtrooms. However, yes, like Muchibi said, Council Muchibi, when he says we are less than 15% on achieving the benefits of technology. And what do I see from where I stand as a social justice lawyer who practices among vulnerable groups? We are not feeling this ECMIS that we are talking about, because for our marginalized groups, even use of virtual hearings is expensive. They do not have the the software, the phones, the smartphones have been as far as Kabong, in Karamoja, name it, so many places in Lamu, trying to advocate for access to justice, represent clients in the refugee settlements, etc. But they do not have the gadgets that are needed for even virtual hearings. They do not even have the finances to buy the data to have virtual hearings. They are relying on legal aid to access justice. And legal aid is largely donor funded. Not our state has failed to pass the national legal aid bill, where a country, Uganda, would then come up to support legal aid services for our indigent or vulnerable clients who cannot access the costly legal services from the courtrooms or from the corporate lawyers. So they are relying a lot on really mediation, informal justice systems to settle their disputes. And you will find that even if we have technology in our courts, if this technology is not inclusive of the various needs of the litigants in our country, then this technology will actually become exclusive. The courts will become exclusive and violate the rights to access justice for litigants. My colleague Miriam has mentioned persons with disabilities. Yes, Let's think about virtual hearings where there are no sign language interpreters in the court. So how will a litigant with a hearing impairment actually follow the court proceedings? If we have, for those visually impaired, if we have the court pleadings, the judgments, etc. shared on ICMIS, if the systems are not fed with software like braille readers, like JAWS systems, etc., to enable persons with hearing impairment or visual impairment to actually find the document readable, then we are excluding them from the justice system in many respects. You can even think about the elderly. The old, there are many social media videos that go around elderly seeking justice in the court systems. They don't know, they are not dictoliterate, they don't know the things, they only know their ordinary, the usual, even actually the cost of coming to the courtrooms for the elderly is still a challenge. So these technological advancements are remaining for the elite. And when Council Karuhanga says the 11 courts regionally that are piloting the ICMIS, okay, how many are from deep in Karamoja, for instance, deep in Lamu, deep in Serere, or are most of them within the urban region? So we are not actually learning as a country. We are not learning. Maybe we need to interrogate Kenya, Rwanda, that went ahead of us with these technological advancements in the judicial sector. Learn from them and learn which gaps that emerged with the emergence of technology. And then how do we address them and ensure that Uganda does not fall prey to excluding people who must actually access justice because their rights are protected in various legal frameworks. We think of internet coverage. We think of power, electricity. You will go to courts in Lamu, etc., and there will be no hearing because there was no power. Somebody cannot access a certain document. There is no electricity, and so on and so forth. So we need to monitor. We need to monitor some of these initiatives that we come up with so that we learn. Council Muchibi has told us about things like the CAS, etc. Did we monitor them and find out what the actual problem is? Is the actual problem actually not technology, or because we are moving ahead in technology? Maybe the actual problem is now with the judicial officers and their performance, actually, and their performance. I have some students doing trial watch, watching some of the trials, the topical trials, the BCJ case, and so on, under Trial Watch project. And one of the challenges that they raise is issues of endless court adjournments. So maybe those are the issues also causing case backlog. So in order to address the needs of all our litigants from the marginalized sector and also from the corporate sector, I think even if we move technology, we must maintain a blended system for as long as our technological advancements do not embrace all our litigants from their respective classes in society. And then what else would I say? Then maybe the turnaround of judgments. Maybe you're right, Ruth, when you say, fine, technology has gone ahead of times, or we are really trying. However, the bench is not trying harder. So the cases are stuck there. The decisions, the hearings are not moving as fast as they should, so that the case backlog problem is therefore reduced. Okay, so we need to assess all these initiatives. We need to do comparative studies with our neighbors to see what lessons we can draw from them and what lessons we can draw from ourselves, and then best practices to cure the gaps. Thank you very much.
Wow, thank you so much, Dr. Tim. As you know, as anticipated from your experience, you have taken us out of Kampala, out of our comfort, just to remember what we're pushing for is a representative judiciary that works for all. And so bringing to the fore some of these challenges and these realities help us, contextualize this conversation to our community. So thank you for that. Mr. Rezida, I want to come to you now because we've had a lot about the statistics, we've had a lot about what's not working. You are a founding partner of, Nangwala Rezida, one of the most, I would say one of the busiest and most, significant law firms as far as the legal practice of this country goes. So I want to ask you about practitioner pain points for this particular question. When we say we want to leverage technology to reduce case backlog, what does that look like for the practitioner? Is the practitioner, one, seeing this impact? But two, wouldn't you say that it's it makes sense to the practitioner if the bench is also meeting them at that same level of impact, in order to have faster resolution of disputes, as we've heard from the rest of the panel?
Thank you so much. Coming at the tail end of these very insightful contributions, reshaping your question is helpful. And even if you hadn't, I had rearranged observations in a perspective of we are talking a lot about judiciary, about systems, about judges, and making the pain points that we practitioners feel. But what about us? What about us? And in that sense, I want to thank the organizers for this session. But I also want to express gratefulness to Uganda Law Society for the focus they have on technology, on digitization. In that discussion, we should center ourselves in as practitioners. We should center ourselves in as practitioners. How are we helping ourselves? How is law society being intentional in ensuring that we are adequately and continuously updated, trained, and ready? Our uptake, our readiness is part of the problem. And we saw this when ECMIS was introduced. Incidentally, ECMIS wasn't the first attempt, and thanks to Mr. Mkiwi for bringing out that chronology of events. How was it received by advocates? And how is it helping us? So, what we face as practitioners, the challenges, the opportunities, is a matter of priority in enhancing our effectiveness in contributing to justice, in ensuring that case backlog is reduced. We have our own share of that problem. That said, what we've seen in practice is the inevitability of what we are talking about. Please embrace technology. Don't be left behind. Training, training, and training. But we also must invest. Invest in infrastructure, invest in resources. Do they come cheap? No, they don't. They don't, not at all. How many law firms can afford? It's one of the bottlenecks. The bottlenecks, we can go through a number of them. But one of them is how many of us can afford and what can we afford? There are so many wonderful things to talk about, and we can go through them if time allowed. Okay? As Law Society have reached out and looked for initiatives, then can, for instance, subsidize on project basis on the cost of technology. Because these programs exist for other initiatives. There are many initiatives. You had, for instance, promotion of green energy, solar. There are projects, World Bank projects. You pay 40% of the cost of whichever solar unit you are taking or solar solution you are taking, and the government pays 60%. Those are funded projects. You see, that promotes and enables. Those are the initiatives we would like to push for. Because remember, and we come back to Judicial Service Commission, one of the roles under the Constitution is to act as a gap between the judiciary, okay, and the public, between the judiciary and legal practitioners. Another constitutional mandate is recommend training programs. It's in the Constitution, not even in the Act. It's in the Constitution. Okay? How do we leverage these as practitioners? Okay? If you are represented as Judicial Service Commission, what are you championing there? If in law society you are not championing it. So we start with ourselves, we push hard for those improvements and ensure that we address the bottlenecks we face. Obviously, one of the biggest bottlenecks is case backlog. Case backlog is such a pain. Each time you mention it, it diverts you from other things, and you can talk about it until. But the statistical trend we see, which I've seen in the recently released report for 2024-2025 by Judiciary, the numerical increase in case backlog has a correlation with many other factors. And that comes to the pain points we see. One of them is a reality check. Okay? You've got a growing population, an increasingly aware population, aware of their rights, an increasingly active population in e-commerce, in trade, okay? And in there, the many lawyers that we are kept busy. And so the filing goes on. If you're a judicial officer and you have 500 matters on your head, you wake up to that every morning. You dispose of 30 and 35 are filed. Statistically, it's like you've done nothing. There's an increase on your docket by 5. Okay? Technology can help. Technology, if well embraced, can help. Technology, if broadly promoted, can help. There are comments about what are the elements in technology that can address the key things we suffer from. You see, you can blockchain and do data analytics that help you understand the trends of adjournments and why, the frequency of adjournments, the case movements, and those trends through analytics help you get solutions. What is the root cause? What are the common features that lead to adjournments? Adjournments have a huge share in the backlog story. Okay? A huge share in the backlog story. How do we leverage technology to answer that? All those tools are available. The judiciary has a performance management and awards committee. It's currently chaired by Justice Mike Chibit of the Supreme Court. They are busy discussing performance tracking because the judiciary has a new performance tool that is coming out. They are busy talking about capacity building. And only this month, that committee sat, looked at where they had been before, traced the history of performance monitoring, performance enhancement tools. The first major one was 2019, but it wasn't yet the first. It was a major one, but initiatives had been done before. Within Judicial itself, there's been resistance to change. I recall very well in one of the annual judges' meetings many years ago, Justice Segonda Ntende, who was still at the High Court, came up with what turned out to be a very unpopular proposal in the judges' meeting. And this was about performance monitoring. It was about peer review. If we're in the division, can you do peer review and see who is doing what and who is sleeping on his or her job? Extremely unpopular at that time. But they have moved. They have moved. It is up to us to ensure that we push that move, that we too move with them. We must also realize that judiciary cannot move in isolation. It cannot. The judiciary is, for purposes of justice, is part of JSC. Part of JSC. There are many institutions in JSC. Judicial Service Commission, by the way, is one of the institutions that is a member of JSC. If you don't have a sector-wide approach to all the things that we are talking about, you are still coming the pains we face. It's like has been pointed out. You're talking about it as registration, you're talking about the death certificate, and people are talking about NIRA. NIRA, by the way, is at the center of technology in the government. All their systems are tech-based. The government set out a national e-governance backbone many years ago. Redundant infrastructure there. Okay? Why should we continue to suffer that I must go and certify a document that is in NIRA, okay, if government is interconnected and all that a judge would need, or at least if not a judge, what a court would need is to access whatever is in an application online, and you see, yes, it does exist in the NIRA database. Why are we holding ourselves back? Is it a question of resources? Resources are never enough. We've heard about, Elson has talked about the amount of money that is availed. Part of the beauty of technology is efficient resource allocation, if you leverage it well. Mm-hmm. How do we assess what that money has done? What do we know? Okay? These are public finances. When money is allocated to judiciary, and law society has no portion of it, if judiciary is going to move alone and leave us behind, there'll be a mismatch. Those are part of the issues.
Wow.
Okay?
Yes.
So we cannot move in isolation. Those are some of the areas to insist upon. Why shouldn't law society get part of that? So that we are trained, so that we are enabled. Okay? You hear MPs, everyone getting an iPad. Okay. In addition to the allowances they get. Do we as lawyers emphasize, for instance, our role? Human rights, good, we talk and so on. And it's a key concern. It's actually one of the major things for law society. But we never evaluate our own role in the economy, the lawyer's role in the economy. We don't hear about ourselves. In the process, we get sidelined in resource allocation and enabling environment as far as we go. So there's a lot that we need to focus on. There's a lot that we should be able to benefit from if we are intentional, if we keep this digitization and technology enabling story that law society has embarked on. Thank you.
Wow, very comprehensive. Thank you so much, Mr. Rezid. I believe you took on the huge burden of, as you said, this is a sector-wide issue, approaching it, looking at justice as a sector. And, the moment you start to go down that road, you realize just how, not to be pessimistic, but maybe how big the challenge ahead of us is. And thank you again for pointing us to the constitutional mandate. I think the question that anyone would have then is, specifically as representatives at the Judicial Service Commission, where do you come in? How do you make these synergies work? And it's good that you talked about performance, because we will actually be going there next. But before that, allow me check in with Professor Mbazira just to make sure he can hear me.
Yes, loud and clear.
Oh, thank you so much. And thank you so much, Professor, for joining us. And I know that some people may consider it a disadvantage, but I like that you're coming at the end of this question, because, given your experience being a pioneer in some of the what have been considered new areas, whether that's public interest or amicus curiae, you have shouldered the burden of, pioneering those within our society, and that has worked in some areas. And so we just want to get your thoughts based on what has been submitted, how you think we can, we can make technology work if it's not working, to reduce case backlog.
Okay, thank you so much, Ruth. Good evening, colleagues online, colleagues that are attending physically. Special greetings to my fellow candidates in the race for the Judicial Service Commission. Just know we are back in the race. I wish all of you the best. Thank you so much, Legal Tech, for this conversation. And thank you much for accommodating me and actually allowing me to appear digitally. Here we see the benefits of digitization because I'm appearing digitally. I would like to respond to the question, and especially as you put it at the start, which was mainly connected to digitization and case backlog. I think it's important that we try to look at answer the question in those parameters, and then I can look at other related things. First of all, we need to understand two things. We've spoken a lot about ICMIS. I know that in addition to ICMIS, just as Council Mchibi has put it, we've had other technologies, but ICMIS was introduced as an innovation that was going to change so many things. But we must ask the question, was ICMIS introduced to deal with case backlog? If ICMIS was introduced to deal with case backlog, what were the causes of case backlog before ICMIS was introduced? You'll actually realize when you look at ICMIS, the way it works, what it brings on board, that it may have very little to do with the reduction of case backlog, because it's not addressing the causes of case backlog. If it is, it's only addressing a very small fraction of case backlog, especially in terms of monitoring the movement of files, etc. My colleague Edison has given some statistics related to case backlog in the country, very depressing. Before the introduction, around the time that ICMIS was introduced, the case backlog that was in the financial year 2021, 2022, it stood at 40,000. 2022, 2023, it moved to 42,960. 2023, 2024, it has moved to 58,446 cases. So just as Edison has put it, when you look at these statistics, you see that actually the case backlog has not reduced. In any case, it's increasing. When you then go back to the main reasons why ICMIS was introduced, there are quite a number, but the major ones, it was introduced to enhance efficiency, just broadly efficiency without being specific what form of efficiency. It was introduced to advance transparency in the judicial systems. It was also introduced to improve public access. Yes, efficiency may have something to do with the reduction of case backlog, but then we must ask, the way the system is designed, is it capable of introducing elements of efficiency that address the causes of case backlog? We know the causes of case backlog are various. Mr. Reseda has touched on some of them, including what we do as practitioners, including the explosion of the population, etc. But there are other things that have almost become organic in the judicial system. One of which, of course, is for a very long time, we've not had enough judges. As the cases increase, we've not had enough judges. Of course, we appreciate the recent appointments. We've seen quite a number of judges appointed, especially at the level of the High Court. But traditionally or historically, we've not had enough judges to deal with the cases. The work culture has been a problem, work culture for both the judiciary, members of the bar, as well as members of the bench. That has been a very, very big issue. Transfer of judges has been a big issue. You know, cases are stalling because of that. Appointing judges to commissions for a very long time, that was a big issue, to commissions and statutory bodies, or giving them mandates that take them away from their primary mandate of listening to cases and giving judgments. Those have been some of the causes of case backlog. Does ICMIS then, in its current form, address those causes? Largely, it does not. When you look at what the judiciary has said about the benefits of ICMIS, it has said it has been used to quicken the payment options. You know, you can quickly pay your fees. It has enhanced access to information. That's, of course, information relating to the cases, issues of personal data management. As much as it says one of the benefits is quick decision making using the judiciary says dashboard and analytics. I'm not technical here to know what exactly the judiciary means by that, but from my little knowledge, I think they are indicating that it can be used to help in the process of decision making. But have we seen that? No, because we don't have that function in ICMIS, the function that would help. ICMIS or other technologies, we don't have that would help judges to quickly render decisions and issue judgments on time. So in the absence of that, then we cannot have cases decided quickly. Yet, just as Council Reseda says, the number of cases being filed is increasing. We appreciate innovations like having judges have research assistants, but even then, without technology, that may not increase the efficiency and the rate at which judges are deciding cases. So we need to go back then and begin to discuss what technologies do we need to deal with the causes of case backlog, including judges not writing decisions in time, for instance, or judges taking a very long time analyzing the evidence, which is largely done in a manual way. Can we then leverage technology to do some of those things? But then the question then which arises, is it a good thing? A few weeks ago, I was in Bangkok, where we convened as law schools, an association of law schools, and one of the themes on the agenda was the question of technology, not only in legal education, but also in judicial decision making. And there were ethical issues that were discussed. Very interesting. If we integrate AI, for instance, to help the judges make decisions, is this AI compatible with our local circumstances? Is this AI free of biases that may actually affect the processes of equity and justice in our case? So in other words, the point I'm making is, number one, what was the purpose of ICMIS? Was it intended to address case backlog? Is it capable of addressing the problems, so the causes of case backlog? In my view, it is not. What has it achieved so far? Is what it has achieved related to case backlog? It's maybe to a very limited extent, but largely it is not. How then do we leverage technology? How can technology be used not only to track the movement of cases, to do case allocation, which could contribute to the speed at which cases are decided, but the biggest problem is the decision-making process. And then what are the ethical issues here? Are we prepared for that? Is the judiciary thinking through that as a profession? Are we looking at that? Because other jurisdictions are already seeing the challenges of, for instance, AI in judicial decision-making and other decision-making processes because of biases. Who is the author of the algorithm that is being used? What is their cultural orientation? Those are things that we need to start reflecting on seriously as a profession, both at the bar and at the bench. Lastly, I think we need to have a scientific study, because whatever we are saying here, all of us, is largely based on conjecture. We are conjecturing based on our experiences, based on the data that we say that may not necessarily directly relate to the issue that we are discussing. So we need a comprehensive process which should be scientific. Of course, one of the considerations will be case backlog. How then can technology be leveraged? What has it done so far? What has it not done? Thank you so much. For now, I will leave it at that.
Thank you very much, Professor. Allow me appreciate you, first of all, for implementing the subject of today's discussion and exercising your right to leverage technology to be a part of this conversation. But more importantly, for taking us back to, I think, the conceptual issues. One of the, as we wind up this particular question, one of the biggest issues in tech policy, as you've mentioned, in Uganda, but actually in all countries around the world, is people having a technology solution and then looking around to understand what problem that solution can solve, instead of doing it the way that you have identified, which is basically, can we have a study, or can we understand what the problem is, first of all, and not just through conjecture, but can we do something to understand what the problem is, and then make sure that the technology we are leveraging is actually responsive to that particular problem, and not just, beating around and hoping that something sticks. So thank you very much for that, and thank you so much to our panelists for their responses to this. Allow me now hand over to Tony. As we mentioned, case backlog is a very big issue. We've spoken about it for such a long time. Mr. Rizida mentioned we can talk about it, but today was also to go beyond case backlog and talk about other mandates or, other issues within the Judicial Service Commission that could leverage technology. So I will now hand over to Tony to take us through that. Thank you.
Thank you very much, Ruth. And also thank you very much, the panelists. First of all, I want to thank the panelists for taking us beyond backlog. You and me realize, for us who are in legal practice, that while us in Kampala, we are partially enjoying the benefits of this digital transformation in the legal sector. Like Dr. Tim has clearly put it, how is a person in Kabong benefiting from this digital transformation? How is a person deep in Busia, where the sitting judge leaves Kampala on Monday because he or she came back for the weekend and appears in court on Tuesday? And then Friday, he or she does not work, travels back to Kampala. But then the digital transformation is centered in Kampala. These courts are not connected to the system. And for me, this conversation is really very, very key, because the panelists we have here are nominees for the Judicial Service Commission. And this conversation, I'm glad that they're at the center stage of it. We as lawyers, and also down to the people we serve, is the digital transformation having impact down? Is the digital transformation having impact when we are having to make submissions online, and then the judgment has to wait because the judge has to make it in person, and he says, I will only give it, in person. So I think those are very, very important conversations. Without digressing so much, let me take on the next question. And this question, ideally, we will start with Senior Counsel Resida. The Judicial Service Commission is responsible for vetting, recommending judicial appointments. In line with Article 142, which gives mandate to the appointment of acting judges, which many members have castigated as a symptom of a broken system. What are your thoughts on how you think technology can be able to help the Judicial Service Commission ensure a more meritocratic, transparent, and objective selection process of judicial officers? Over to you, Counsel Resida.
Thank you, Tony. That's a very fundamental question. It touches the heart of the concerns of judicial practitioners, court users, and the people we serve. I'll not comment too much on the aspect of acting judges. It's a matter in court. It's one of those things that we do not delay in the Supreme Court where it is resting. It's one of those things that agitation needs to come up for resolution. There are pros and cons. I recall at one of the Law Society AGMs, I think it was a pre-AGM session, the question was raised. And the Attorney General had this to say. He said, on the one hand, we complain about competence at the bench. And so when an innovation is done and it's in a manner that says, okay, issues of competence, issues of which are concerns that are being raised, what if we have judges appointed in acting capacity for 2 years, and we get a sense of their uptake, their aptitude, and whether they measure up to the job. Then he said, now, when that is done, the same lawyers that complain about competence, we now say, but how can you do that? It's not in the law, it's against the Constitution, and so on. And obviously, those are live debates. But then the short answer to that is bring it out as a debate. Let's see if we want to make amendments so that it is within the law. There are reasons why acting capacity was never considered. Okay? But let's not just do it. If we want to do it, let's do it following what we should do. But again, that's a matter in a court. You know, there is one thing about technology coming to your question, Tony. One of the most beautiful things about technology is that it enhances transparency once you deploy it and you use it. It removes subjectivity. Everyone goes in and is appraised, the applications are received, okay, through that forum, okay, with little human interference or manipulation. And so, when you hear that transparency enhances trust, that's what it means. And one of the things the justice system should never suffer, which now it is suffering, is confidence. Transparency enhances confidence. And so it's one of the things that matters. That is as far as appointments are concerned. And technology helps throughout the procedure from the time you, first of all, communicate vacancies, communicate the specifications you are looking for, communicate the kind of applications. Why shouldn't you have a uniform application system and everyone fits in it? Okay? And let technology assist you to give that confidence of transparency. I'll take it a bit further than the question. There's a complaints handling procedure at the Judicial Service Commission, but it's very well structured. There are two different departments. Very well structured. If you look at the structure, you look at the mandate, you look at how it's supposed to run on paper. Very, very good. But what do we hear about that? That, you file a complaint against a judicial officer, and that complaint may actually not reach the commissioners. It could end at the front desk or get lost somewhere in that system. The beauty of technology, that goes away. That goes away. That would be addressed. So technology is a big enabler in the transparency aspects, okay? And that transparency addresses everything else. Talking about the merit aspects of the appointment of judicial officers. We're talking about tracking performance. We are talking about there's in 2024, there's a time 834 applicants were shortlisted for grade 1. Shortlisted, the applicants were in the thousands. And there's a question of the next stage. What happens the next stage? So they go aptitude, they go through all those, and they're told to come for the next stage. When they come, the number has now increased. How? How? We finished aptitude. You told us we are 834. How did we become 960? What happened in between that date and when we have come now for the oral interviews and so on? Technology? It won't. Not only that, if you try, it should drive print. Okay? Or who try to fidget with it. If it is Edison, it will shout, Edison. This is the one. Okay? Not only will it shout, it will show at what point, when, the hour to the second. So it addresses, it enhances. It enhances. And so the thing about technology, it's about the efficiency, the trust, the timeliness, and optimization of resource allocation, resource utilization. Those are matters to continuously insist on. There are jurisdictions that have gone ahead of us, but we are not terribly behind. We are not terribly behind. The question is, even what we have installed, you find there's installed capacity, even with ECMIS, installed capacity. But how much of it are we using? If you are challenged to tell how much of your smartphone you are using, you'll be surprised. You could be at the 15% we are hearing, but it's your phone, you have it. Okay? So there's been a lot of investment in some of these areas, but is it deliberate to ensure that the appointments are not as transparent as they should be? Beyond the lack of budget allocation and technology acquisition, is it deliberate? So that we continue with this system that everyone says sidelines merit, brings in interference. Those are matters we need to study. Like Professor Mazira said, we are here talking generally, but those are matters to study to understand why. We even should do a few things differently. I would love on a session like this, where this is just about Judicial Service Commission candidates, but it would be very interesting to have someone from judiciary talking about digitization in the judiciary, the journey they are on, so that we are at the same level of information in the efforts that are being taken. Because, as I keep saying, the biggest mistake is for one sector to move and leave the other behind. That would be a big drawback. We are conjoined, and we must.
Just right from there, Councillor Rosida, I would want to Professor Mbazira, if he's online, to just pick it up right from there. Professor Mbazira, in his campaign tag, he says linking the bar linking the bench, and linking the country. The Judicial Service Commission, which is responsible for the appointment of the judicial officers, members of the bench, is where we are looking at Professor Christopher Mbazira vying to go. And in line with linking the bar, linking the bench, and linking the country, what are your thoughts on the best practice with respect to the appointment of members of the bench in a transparent manner by use of technology? Professor Mbazira, take it up from there. Thank you.
Thank you so much, Tony. Interesting conversations here, and especially when you bring in the dimension of technology. Of course, in my campaign, I ran my campaign, and I'm running it, among others, on the promotion of transparency in the appointment processes. And one of the things I
Recording stopped.
Happen in the Judicial Service Commission is for the public to be involved and the public to keep tabs on the appointment processes. Sometimes the public simply sees an advert in the papers. Back in the days, you wouldn't even see an advert in the papers. You would simply see in the news that judges have been appointed. So these days, the public sees an advert in the papers, and then the next time they see judicial officers being sworn in. That is something that we need to change to ensure that the whole process is open. The public is able to follow the process from the point of advertisement, the process of interview, and technology here can play a role. For instance, we've had technology in the form of television and radio for a very long time, and other jurisdictions have used it to make appointment processes transparent. I did my postgrad studies in South Africa, and I was fascinated by the appointment processes where the processes were televised. Processes of appointment were televised, and they would be open to the public. The public could attend physically, they could follow the processes, especially the interviews of contending judicial officers, direct questions at them. The Kenyans have also done the same. So that is something that we need to embrace, and we are lucky that actually we now have more channels of involving the public. Initially, as I've said, it was only television, the few that could access television and radio. But now we have all these technologies, including what I'm using now. So the commission really needs to embrace these technologies, not only to publicize the candidates that are vying for judicial posts. Their CVs should be put out there. Technology could also be used, actually build a system of getting feedback or getting vetting from public vetting of the candidates, so that members of the public are able to give their views on the not only competence of the candidates, but also to give their views on the moral integrity and preparedness of the candidates. So there is a lot that can be done through technology. And interestingly, as technology is getting more in terms of availability, it is also getting cheaper. So the commission can actually use these technologies at a very minimal cost or no cost at all. Some of the technologies are out there right now. We are using Zoom, we are using Spaces, we are Space, we are using YouTube. The other area where technology could be leveraged, one of the proposals on which I ran my campaign is having what I call a Judicial Service Commission appointment manual, which details the procedures and the processes of appointment, again, from the point of advertisement to the point of recommendation for appointment to appointment in the case of lower judicial officers. Again, technology can be used to put this process out there. And I think Council Resida has already touched on this in terms of how technology can be used. These days, we are seeing even institutions that are not so resourced are actually using technology. For instance, academic institutions are using technology to manage application processes, application and admission processes. You are able to apply online, you are able to track your application, then you are able to get a feedback online. We should do the same, and we should also digitize and put the processes out there so that the processes are open, they are transparent, and containing candidates as well as the public is able to follow the processes. Thank you.
Thank you very much, Prof, for the well analyzed analysis of the question. This takes to Dr. Atim. Doctor, you realize that one of the challenges, even in your submissions, of the justice system is how the underprivileged are able to access justice. My question is, technology can either entrench or break barriers. What specific tech-enabled strategy would you propose to ensure the Judicial Service Commission actively and successfully identifies and recruits qualified candidates from underrepresented groups, such as women, young lawyers, and persons with disabilities? Thank you.
Thank you very much, moderator. I think let me start from the point of really recognizing the technological gains that the Judicial Service Commission has utilized so far. I have seen the adverts from Judicial Service Commission for the respective positions for magistrates, for registrars, etc., and they are open to the public. The application process is also clear. You send your application to this portal or email. It's always there. Unfortunately, I have not been privy to maybe the Judicial Service Commission reports that should tell us what then is the problem. Is it a technology problem? If anybody can apply, any Ugandan can apply from wherever they are. I have friends in Arua who have applied for these positions and followed the processes and not got, irrespective of which region you're coming from, irrespective of your gender, you can apply for these positions. And when you apply and follow the processes, what then is the problem? During the time I was running the campaign actively, one of the challenges that was expressed, or two, by some of the people I spoke to, one of them said, you see, this aptitude test we do it in shifts. It's the same exam, so it leaks. By the end of the process, those coming in the afternoon, who are majorly, and the person told me, you see, and those who are scheduled to come in the afternoon are usually those connected to the who and who's in the judiciary. So they already know the answers and etc., etc. So you find that they will also end up on the successful list. I'm not so sure how true that is, but that was said, and it's a feedback I'm putting out there to the legal fraternity, to the country, so that we understand where the problems lie. There were also allegations of people are paying the members of the Judicial Service Commission to get onto the successful list of the judiciary and so on. How much? Millions. The IGG the other day spoke about public service jobs being bought using millions and etc. That is not a technology problem. The technology is actually being utilized. That is a human problem, if it actually does exist. So it's important that we become privy to that information. Maybe when Miriam and I are successful in this Judicial Service Commission campaign, we will become privy to the challenges from the horse's mouth on the other side, so that within that those who have gone ahead of us to actually be Judicial Service Commissioners, so that we begin to understand what the actual problems are, because technology in itself may actually not be the problem, and then we address. We can, I acknowledge that it's good to open up. I've seen Kenya doing that, open interview processes and so on for Judicial Service Commission candidates. We should open up for members of the public to bring any queries, legitimate queries about a particular person, their ethical standards in really meeting being employed for this position as a judicial officer and so on. And they should be honest and legitimate, and if transparently and fairly verified. All that can be there. I don't know if the Judicial Service Commission, our predecessors, have actually been putting that initiative in place. Council Resida says there's actually a complaint mechanism, but everything about the Judicial Service Commission from when I started this campaign seems clouded in secrecy. If there is a complaint mechanism, where is it? What does it say? What kind of feedback does it give about certain judicial persons who are applying for Judicial Service Commission jobs, and so on and so forth? So I think there is more to really understand, but in terms of whether eligible applicants can apply irrespective of gender, irrespective of origin, etc. It's there, only that they are not getting in. Either they don't have the money to pay the Judicial Service Commission people, or they are not getting linked to the exam, or they are not on this special list that comes from orders from above, that these are the people who must be judicial officers and not those ones who have passed the interviews, maybe, and it's not technology.
Thank you. Let me have Elson pick it up from there. Elson, your hashtag says the lawyer's lawyer. Yes. And oli mujawa omusajja asinganze. So I want to pick it up from there and move away from the transparency bit. Elson, in the lawyer circles, you know for a fact that one of the frustrations of our senior colleagues like Resida, who tell you that I am done with court, I can't, is because they are not impressed with the quality of judgments that we are getting today. Many senior colleagues in the profession will tell you that I no longer read judgments from 2010 or 2014 because they won't give me what I need. In line with that, what is your thoughts on how best the Judicial Service Commission can use technology as a basis of evaluating performance of those you intend to promote, of their previous judgments, so for example, for the benefit of bringing confidence in the public to the judiciary? Thank you. Take it over from there, Ellison.
Thank you very much, Tony. The challenge with, you're talking about the quality of judgments. I think it's fair to say that some judgments are very good. Some judgments may not be as good. I think that has always been a historic problem with judgments. There was a judge who we shall not mention. Back in the day, they used to appoint people as acting judges, and they would only confirm them. But there was a particular judge who had never been confirmed, but he has been a judge. If you read the law reports, he remained acting throughout his career. And the problem they had is they said, you know, you fellow, the day you are not overturned on appeal, we shall confirm you. But the man failed to not be overturned on appeal. He kept giving out judgments that his colleagues, he was very consistent. he was very consistent in giving judgments that the Court of Appeal found the need to overturn. So yes, and that's one of the ways. I think it's important that in evaluating, for example, a judicial officer going to another level, we must have what they call in the HR world a 360-degree evaluation. What do the lawyers think about you? What do your peers think about you? And statistically speaking, what is happening on appeal? But again, this takes us back to our problem. We can't do that at the moment with backlog because we have been told, for example, that the Court of Appeal is only hearing appeals that have been filed 10 years ago. Many of the judges who wrote those judgments are now in the Court of Appeal. And therefore, that sort of evaluation may not work. However, we need to have a proper 360-degree evaluation. Ultimately, judicial service must be considered as a service. And as a service, it must also be considered as a job. The people of Uganda are paying for that job. HR tools that are used in many other jobs must apply to their lordships with the greatest of respect. Performance evaluation must include peer review, must include a 360-degree, I think so they call it now in the HR world, a 360-degree evaluation. We need to know, what do your peers think of you? What do the lawyers appearing before you think? And how good are you above? You see, if you just use only one method, it always causes a problem. I'll give you a quick example. There is a judicial officer who people were saying we need the statistics to see that you're doing a good job. You need to be evaluated on your statistics. So somebody produces for you very good statistics, says he has closed 300, 400 cases, but he's actually closed them. He's walked into his court and said, as long as people here, if these are family cases, we're in a village somewhere, if you don't have letters of administration and you're a beneficiary, we don't take suits from beneficiaries in these courts, close all those files. You know, someone who is closing cases en masse without actually hearing disputes ends up producing for you very good statistics. But if you give him a 360-degree review, you find out that this guy is very good in another field, not as a judicial officer. He needs to really try his talents away from the bench. So you need to have that whole holistic approach. We need to start looking at this as a service, and all through, not just the judicial officer, but the courtroom. The courtroom needs to be a service. It needs to ensure that we have technology, you're saying how it can enhance. The courtroom needs to be a service. If someone can't be available in court today because, say, he's in Nairobi and he's the lordship, does he have Zoom in Nairobi? Can he hear me? Start taking the people of Uganda seriously. The Constitution says that judicial power is derived from the people and shall be exercised in accordance with the norms, wishes, and aspirations of the people. Our people don't want backlog. Our people don't want delay. The Constitution has commanded us that the judicial power that has been given is given in their name and must be exercised for them in a way that promotes them. This power is the power of the people of Uganda. The other thing which I will say very briefly is that when you're looking at technology and how it can help the Judicial Service Commission, it must also not be a one-size-fits-all package. You're looking at a number of HR tools, and it has become clear to me over the course of this campaign. Some of my colleagues were saying that they had stopped. Some of us have never stopped. But it has become clear to me throughout the course of this campaign that sometimes one size fits all doesn't actually work. So, for example, these HR tools, clearly there are psychometric and evaluation tests that are coming out. But many lawyers who are, for example, applying to join the lower bench find many of these tests are not relevant. Find the whole process itself is opaque and not transparent. So technology has a huge part to play, but ultimately the attitude we must have must be an attitude of service. We must realize the boss is the consumer. I'll close here. I don't want to take too much time, but you know, and I also don't land in too much trouble with their lordships. But you know, the lordship, the title, you know, when you go to court, you are before a worship, you are before a lord, and you pray. Say, my Lord, I pray. And then when he tells you, go and hang, you're hopeless, you tell him, much obliged. I think the idea of calling their lordships, if you look at our constitution, is the constitution assumed it would be the lordship of Christ, servant leadership, that they shall wash the feet. So I think once you take on that high judicial office, there is so much pressure and so much stress, and they are seeing it. Many of our judges are seeing it. Judges are sitting on 1,000 case dockets. Judges, until they introduced technology, this speaking and it's getting recorded, judges were recording with longhand. Many of our judges have back problems, hand problems, eye problems. Some of them even got liver problems just from sitting there. If you just look at the health crisis in the judiciary caused by the sort of backlog and stress that's coming from the judiciary, you realize that we need solutions that help, because as it is right now, it's not working for the court, it's not working for the user, it's not working for the public. And we need to think really outside the box, and technology is a good helper, as of course is what I've kept insisting, 1422. But we'll get into that, I'm sure, later on. Yeah.
Thank you very much. Olisangawo musajja. This is to Advocate Mariam Mbabali. You realize that one of the challenges still within the very question and the conversation rotates around the constitutional provision, Article 142, which gives mandate for appointment of acting judges. And the traditional approach in this appointment of judges is basically focusing on their CVs, is basically focusing on experience. But corruption thrives in an opaque environment. There have been cases of the public outcry on corruption. What are your thoughts with respect to doing a health check on the wealth of the judges that are seeking promotions, doing a health check on what Oliver Kamia called a lifestyle audit vis-a-vis their income? Over to you, Advocate Miriam.
Thank you, Tony. That's a very nice question. I think we need to give each other some grace. The culture that we have built, first of all, we have to appreciate the judges, the people who make it to the bench, were once lawyers, were our colleagues. So when did we get here? Who built this culture that we are criticizing? How about we look inwards? If we think the people are corrupt, where did this begin? Maybe capacity issues. You as lawyers, you're already corrupt. So when you come at the bench, it's not any different. So I think we're giving it a very abstract, picture. When you look at the statistics and the IGG comments of let's do an internal health check, has it crossed your mind that some people make it by the time they're lawyers? So when they get to judges, they're already there. So what's the measure? So since we are looking at technology, I'm looking at just myself. So I make it as a judge, and you're like, oh, let's look at Mariam as a judge. Has it occurred to you that she's been practicing all these years? She's somewhere before she gets to the judge. The judgeship just is an addition. Let's learn to develop a better culture, to give each other some grace. Secondly, we are the corrupt lawyers that turn into judges. Let's go down to the grassroots and just get it from there. And by the time they get to where they are now, you should have immunized the corruption we are talking about. Then we are talking about technology and how it can help come out some of those issues. Technology will come in to collect the data. We're not saying that we should get people we're not giving an opportunity to everybody, but let's get into collecting the data for all the lawyers, such that when they become judges, you already know who those people are. That's the point of technology. It should enhance. We should use it for a softer life. So we can't get where we are. We'll end up with garbage in, garbage out. So we are hoping that technology will be the saving grace. No. Collect data. It will make life easier when you get to trying to analyze these judges. Thirdly, we are looking at them with lenses of, oh, these people, they must be. At the quality of the judgments that they're doing. Personally, mental health sits dear to me. And I'm thinking, have you used your technology to assess this judge? That when they are in their courtroom, they are triggered with these cases? How are you supporting them before you come in with the pointing fingers? How are you supporting this judge who is seated 9 to 8 p.m.? How are you supporting their mental health? Don't pick and choose how you want to treat these people, these colleagues of ours. Don't pick and choose. If you are supporting them with technology, use it as a tool to say, okay, she's logged in at 8. What kind of cases is she using? What kind of person is that judge? We are putting these cases before this very person. Maybe they are triggered. Maybe they have had a bad relationship with money, and now you're putting this huge case before them. How have you supported that judge? So we are not setting them up. So culture, it's strategy for breakfast. What's the strategy? How are they oriented into this new life as judges? So let's not get to the tail end of things, but let's use all the tools before us to try to look at a wholesome picture and see how we are using all the information before us to better the judiciary. So, Tony, I don't know if I'm answering your question. To me, judiciary encompasses all of us, the court users, the lawyers, the litigants, and the judges. So when you're saying one of them is corrupt, how did that person get there? There should be a party, either the lawyer, the litigant, or the judge that is inducing this person to get to being corrupt. So I think the system needs to be hijacked at the level at which it is, and we are able to be better at what we do as lawyers, as the users of court, and the judges. So let's not get to the tail end, but let's use the tools, and we'll be better at that. Thank you. I hope I've managed to answer your question.
Thank you very much, Advocate Mariam. I love the fact that Advocate Mariam is cognizant of the sacred place, so she treats carefully. Thank you. Over to you, Paul. Paul, in your hashtags, you talk of chain breakers. talk of breaking the chains. In line with our question, do you think technology could be integrated in Judicial Service Commission's disciplinary and performance management functions to build a more accountable bench? And if so, what are the pitfalls to such systems, and how do you think we can mitigate or work around them? You are a published advocate in that area, and we would want to pick your thoughts on that. Thank you.
Thank you, Tony, for that question. True, I'm publishing on ECMIS since 2022 commencement to date, and I've addressed all those issues to be coming out soon. But allow me to clarify a few things before I go to that direct question. One, with the ECMIS, we are not yet at automation. We are still at transformation. I've seen some mix of the two. Transformation is a process. Automation is the final. So we are not yet at automation. Secondly, the dynamics of the human rights issues regarding technology are everywhere in Africa. And one of the studies conducted by Frederick Drabo, writing about digitization of African justice systems, noted out power outage as a problem in the entire Africa and a drawback to digitization. And in view of that, I'm drawing to Dr. Patricia. Power problem is not only in Kabong, not in Iguru, even it is here in Kampala. Ever since Umeme went and we got UED cell, we are back to Ugandan Zikiza board, whereby you have a full week no power, but you are in Kampala. There is no power, a full week, just here in Kampala. So the problems in Kabong may not be any different from Kampala. You will still face some of those issues, but the concern is mitigating. How do you mitigate? The third clarification I wanted to make is that ECMIS started with 7 pilot courts. That's the Supreme Court, Court of Appeal, 3 divisions of High Court, that is Land Division, Civil, Commercial. Then we had Magistrate Court was Mengo, was the Magistrate Court in the pilot courts, and Iluwero. Those were the 7 pilot courts. As I talk today in the 2024-2025 Judicial Performance Annual Report, it has been piloted now to 26 courts. 26 courts now have been switched live. And though some of those include those not in Kampala, like Jinja, Kachira, Lugazi, they are all having now ECMIS. The other clarification I wanted to make from what Professor Mbazira was saying is that ECMIS is not, did not come to clear backlog or address backlog in its sense. I want to understand, ECMIS is a tool. And being a tool, it is one of the tools we can use to address the backlog problem in its functions like efficiency, e-filing. I don't need to move to court to file. I can even file from my home. Issues like e-payment, I can pay from anywhere. Getting notifications, I don't need to go to court to find out. So that efficiency helps in turnaround time. And I don't need to always be facing the court officers. I can do my work only interfacing the system. So it is just a tool also helping to reduce on backlog if it is managed efficiently. Now I want to come back to the question you've raised to me now regarding my hashtag, the chain breakers. Chain breakers is wider, and it is even delving into technology issues. One of the things I think that we can improve the judiciary, technology can do a lot. One, the judiciary has always been singing about performance standards, which are not forthcoming. We don't see them. We can easily use technology to track performance of judicial officers. You can synchronize and have a system you monitor. Even as the head of judiciary, PJ, for instance, High Court, you can monitor what is the judge in Luwero doing for this year. How many cases have come in? How many have been determined? How many have been heard? How many are pending? You can monitor using technology. You don't need to, again, sit and make a budget, put allocation. We shall go and visit Luwero for a full week. That is wasting taxpayers' money. Technology can easily solve this without you going to Luwero and camp there for a week and telling us we are carrying out a census. No. Technology can easily do what? Do this. Secondly, applications like habeas corpus. In other jurisdictions, if you see Sierra Leone, how it is being done, there is a red flag. When an application for habeas corpus has been filed, the system will not bring a red flag notification to all the judges that habeas corpus application has been filed, because by its essence, it is urgent. It is urgent. So that red flag notifies immediately all the judges that there is an urgent what? Application. The same applies to applications of an interim nature, applications of a temporary nature. Technology can help you. But here, you file, then you start writing letters to fix the matter. After writing letters, then you go and again ask, when are you fixing the matter? We are really not progressing. Yet the government, the judicial has invested a lot in technology. And one of the reasons that I don't need to go to court to ask a date. No, I've uploaded my letter asking you a date, fix, upload the application, I'll see it and wait for that date to appear in what? In court. Here they tell you, write a letter, come follow up. You are not following up. Why am I following up when we are in the digital world? We are wasting a lot of time in doing these visits to court, congesting court on unnecessary issues. So we can still use this technology. You can easily know. You see now the judiciary has launched its annual performance report that was on yesterday. Yesterday but one. That's when they launched it, but that is far away from the financial year. The financial year ended 31st July. We are getting a report in September. Yet we are using technology. What are we doing? There is a mismatch, or whether we are really utilizing technology well, because these statistics can easily be captured. The principal judge can be in his office and he knows Judge X has 30 pending judgments. Looking at the system. But here they say, they wrote to the judge, how many judgments do you have pending? The judge also waits to respond as clear as the judgments. By the time he responds, he had 50, he say, I have only 10. Because things are moving manually. But if you have your system there, you don't need even to ask a judge. You just put an inquiry. Why are we having 50 pending judgments? I can see them on the system here. So there is that lack of accountability and leveraging technology to cause judicial accountability, which is easier and we can easily manage it. That is part of chain breaking. That if you use technology well, you break these chains of poor performance. You don't need a report on performance standards. You don't need to go to Nairobi, to UK, to benchmark how the judiciary is there, do their work. You are wasting taxpayers' money. Just apply technological tools. They will do it. An example today, why do we still need assessors in criminal cases? Assessors? In this 2025, we have assessors appointed to advise a judge? No, we can do better than that. Judiciaries in China are using, employing AI to do that, and it is doing it effectively. So there is a lot we can really improve. The judiciary is not even talking about the judgment writing tool. I heard about that word like 10 years ago. Judgment writing what? Tool. Today it has not come out. In this digital era, how can we fail to have a judgment writing tool? So we avoid so much discrepancies in how judicial officers come up with their decisions as a guide, not necessarily what they must follow. So technology can score a lot, but we should appreciate certain things. There is a process to reach where we want to be. One of the things I challenged the judiciary when they had launched ECMIS, and I made it in the annual general meeting of ULS of 2022 at Entebbe. I told them, you are going to be taken to court. You don't have any legal framework backing this system. The regulations that provide adjective law in Uganda, procedural law, are all manual based, and they are applying something different. Other jurisdictions where digitization has been done, the first thing they work on is legislation. So I fought that battle. I'm happy that we have now the judicature, electronic filing, service, and virtual proceeding rules, SI number 21 of 2025. I'm already trying to analyze these rules. I participated in their draft, but I'm also analyzing them because they also have a provision which can allow you to file manually in the case of a situation of network failure or system breakdown. So we can break so many chains using technology, but these have to be thought about.
Thank
Digital
you very
literacy,
much.
among others. Thank you.
Thank you very much. Members, we planned to run this space for strictly 2 hours. We already late by 12 minutes. Plan to start at 7:30, which we did, and we intended to end at 9:30. Our average time per candidate, we expected to spread max 7 minutes, 7 times 7, 49 times 2 questions, where we are going. So I want to use just 2-3 minutes. First of all, it would be very unchristian of me if I do not appreciate the leadership of the Radical New Bar for its efforts in the digital transformation, the brains behind the annual Law Tech Festival, which was really a very big success. And I also want to thank many of you who were really very, very pivotal in participating and attending. Senior pleader Resida, Elson, Miriam, Atim, part of the organizing committee, Paul Muchibi, and many of you. And this, in my opinion, is part of the journey from, we are saying, can we promote this? Can we have this conversation going? And I want to thank you for honoring this invite. I will take the honor to ask the President of Uganda Law Society to give us the closing remarks in the next 7 minutes, because I will give members each 1 minute. That 1 minute is, what is that tech advice you would give to a young lawyer today? Everybody will be given 1 minute to take on that as the president prepares, as the tech team prepares to have the president to have the parting shots. I also want to thank my co-moderator, Ruth Mohawe. I picked her short notice. I says, you need to join us. And I think she has done a good job. I think she deserves a hand clap. And I also strongly think that these gentlemen have done the topic justice. I think they deserve a mighty hand clap. And the ladies have done an exceptionally good job, and we need them. I was very, very delighted when I saw Advocate Atim and Miriam joining us. You'll get to learn that the Judicial Service Commission today, I think, if I'm not mistaken, how many ladies do we have? Pardon? Are you sure? The last time I checked, we had only one, if not none. So I am glad if we have ladies getting, happy to join this. Ladies and gentlemen, may I take the singular honor to start with Professor Mbazira Chris. Kindly speak to us in 1 minute on that tech advice you would give a young lawyer today. Thank you.
Thank you so much, Tony. I'm not sure I want to advise only young lawyers as far as technology is concerned. I think what I'm going to say applies to all of us. I think the biggest challenge is ethical use. We cannot avoid technology, especially AI. It is doing wonders in terms of helping lawyers to do research, prepare cases, present in court, and so many things. Study the map the judiciary. There are quite a number of things that AI is doing, and indeed every law firm of the future must invest heavily in AI and related technologies. But the biggest question is the ethical issues around the use of AI. Those of us that are in the industry of legal education are already facing these challenges. We are using AI, our students are using AI, but we are encountering situations where actually AI is doing things that the students should be doing, the things that should test their competence is instead being done by AI. So young lawyers invest quite a lot in AI. Senior lawyers as well. Let's use AI, but let's use AI ethically.
Thank you very much, Professor.
Is what is ethical use? We must interest ourselves in that as a society to define the parameters of ethical use of AI. Thank you.
Thank you so much. And let's hear from Senior Pleader Resida. That's fine. It's well. It's well.
Thank you. I know it's 1 minute, but I also want to thank the organizers, the moderators, Uganda Law Society leadership for, again, emphasizing tech, the listeners who are still with us, and both online and physically. Thank you so much. Now, to sum up for young lawyers, I think everyone should begin by emphasizing ethical use of technology. That must always be emphasized. To sum up, I would not just tell young lawyers, like Professor Bazida said, but especially young lawyers. The future of law is in the courtroom, is in the boardrooms, is in your chambers, and the cloud. And the cloud. If you don't equip yourself to master basic skills in those spaces, you are going to be left behind. You have to know how to blend technology with advocacy. Because one of the things that suffers a lot, virtual hearings, demeanor of witnesses, art of cross-examination, even the art of negotiation in transactions, with so much use of technology, is advocacy, is developing skills, negotiation skills, developing drafting skills, because it is easy to infeed questions and everything is drafted for you. So please blend technology with advocacy and be mindful of the future that includes the cloud. Thank you.
Thank you. Develop skills with advocacy. There you are. Over to you, Dr. Patricia.
Okay, thank you very much. To the young lawyers, I think I would say let's enjoy enjoy using technology in all its forms, but maintain professional conduct, because we know our legal profession is a profession that also relies on professional conduct. And we've already been told this technology does not forget. So you don't want to apply for a judicial position or any other position, and then technology is rebirthing some of your unprofessional conduct. Thank you very much.
Thank you very much, Dr. Patricia. Always very precise. I don't know why you have left me with over 30 seconds. Maybe
I'll use them.
maybe we'll get back to you. And then to Ellison.
Yes, allow me to join my colleagues in thanking the organizers. What advice I would give to a young lawyer? Of course, now there's reverse mentorship. I take advice from young lawyers when it comes to technology. But in 1450, I think it was, a man called Gutenberg invented the printing press. It democratized knowledge. I think the first book they published was what was called, I think, the Gutenberg Bible. And from then on, books became published, knowledge was democratized and spread out, and it leaped Europe ahead of many of the other continents on earth. I think my advice to young lawyers is that technology, AI, is the printing press of today. You are holding in your hands. Back in the day, we had a book, a pen, a library. Now the tools of our trade are your phone and your password. You are walking around at an historic time in the history of the world. You are back in 1450. The printing press has been made. You need to know how to read. You need to understand where technology is taking you, and you need to understand it is an equalizer, it is a barrier breaker. Understand the tools of the trade that are here. Understand how the world is changing. Understand that these systems we talk about, even for court systems like ECMIS, are not chains, they are wings. Fly, fly, fly. This whole world depends on how good you are. This profession depends on what you're going to do with the equalization of knowledge. Never again will someone stand before you in a dock and tell you things about science and math, English and French that you cannot check instantly, immediately, and put the man or woman to shame. So colleagues, young lawyers, old lawyers, these are wings. Take advantage of the moment. And as you do it, some of us are a bit old. Teach us. Don't leave us. Thank you.
Thank you. Thank you, Ellison. Thank you. Thank you. Thank you. Thank you. Thank you. Ellison keeps switching. Today is a millennial. Tomorrow is a Gen Z. But over to you, Mariam Mbabali.
Thank you. Thank you. I like the energy for the Ellison people in this room. You could channel that to me as well. Thank you. So I would tell a young lawyer today, you're here at the right time. I would tell a young lawyer today that technology doesn't replace your thinking capabilities. It is here to enhance. And I would remind a young lawyer today that the law is still what it is. It's still the law. So as we are engaging in technology, you are still a lawyer. So it's not here to replace you and your brain and your capabilities as a lawyer. So show up and look at technology as an enhancer. Thank you.
Thank you. Thank you very much. Then over to you, Paul. Paul is always with the young men, day in and out, at a place where we all, keep cussing immediately we leave. We only go back after some time. Over to you, Paul.
Thank you, Tony. Mine is simple to the young lawyers. Actually, young lawyers don't have issues with technology. The issues are with the senior lawyers. Most of the young lawyers are tech savvy. They know how to use technology. The only concern is ethics and also authentication. We have had so many cases we've reported of hallucinations where wrong citations have been used in submissions. Even courts have disciplined some lawyers for misleading them using AI. So that is what the young lawyers need to look at. My biggest advice would go to the senior lawyers. Change management. We need to change how we think things. Technology is here, it is not going. You either change or you are left irrelevant. You have to move with technology. Let us not always delegate to young lawyers. Time will come when you have to log in the system yourself, but even you don't know the password. It has happened. I've seen them in court. They come and say, log in the system. Then he calls the clerk. What is our password? So really we need to appreciate where we are if we are ready to leverage technology. Let us agree technology is here, is not going. Let us embrace it and let us use it to improve our service delivery. Thank you.
Thank you very much. Let's move on to our president, Isaac. Somebody kindly give us some parting shots. We applaud you for starting the digital journey, and I will be very glad to hear from you. I also want to thank, before he comes in, our online users. It is shocking. We are having over 1,000 people online. To you, the panelists, I think you are crowd pull. Having over 1,000 people up to, I think that shows that they were interested in what you are speaking. And if we have over 1,000 still on, that means you have spoken to our hearts. I want now to also encourage that these Lego Tech Dialogues are going to be, we are going to be having them bi-weekly, every Thursday, and we will be in the same place. If not here, we'll be up. We want to have this journey continue, and we pray that you spread the gospel so that we continue in different areas. Over to you, Mr. President. Kindly speak to us. Thank you. I think we have lost. we have lost the president. Advocate team was demanding for her 30 minutes, 30 seconds. Ladies and gentlemen, may I take the singular honor, unless my co-moderator has something to add on?
No, just to thank the panelists for your time and for attending to this and to these questions. On behalf of the audience, and on behalf of the electorate, I think even just from this conversation, we have the confidence that whoever we send to represent us on the other side will be thinking about those issues, and for us, that's what matters. So thank you.
Thank you very much. Let me take the singular honor to bless you and wish all of you success and give you confidence that as members of Uganda Law Society, we believe you are the right candidates to represent us in the Judicial Service Commission. We wish you success. May you have a beautiful good night. Thank you. Wow. We will have a group photo. Thank you so much.